Murder is a group of crows. But can the murder of crows actually commit the crime murder? Animal committing a crime and going to jail might sound a little sus. Sus is the genus of pigs. Why pigs, you ask? Because they are notorious for not only attacking but also killing human beings. For example, in France 1386, a pig was accused of killing an infant child. This wasn't simply a case of farmer dealing with a dangerous animal privately. This pig was formally arrested, imprisoned, then solemnly tried in court of law. She was then found guilty, was sentenced to be mutilated in its leg and head, and then was publicly hanged. This wasn't some isolated incident. Animal trials were common in many European regions. The courts were not just religious courts, but also secular courts who took part in animal trials. The question arises that were they truly ascribing criminal intent to a pig or a rooster in the same way we would to a human? The justification for trying pigs and other animals was less about the creature's intrinsic legal standing and more about what the trial did for the human community. For these societies, it provided a ritualized space, a place to process the transgression against the societal and moral norm. It was reaffirming their status as a human beings, who were the only one capable of dispensing justice. In modern times, an animal cannot be tried for a crime. This is because we have defined crime very specifically, and that definition only includes human beings. An act is said to be a crime when there are two specific human elements present: actus reus, the guilty action, and mens rea, the guilty mind. So why is an animal excluded from this definition? Why can't it be tried for a crime? A primary reason lies in the legal principle of mens rea. This Latin term means guilty mind. For an act to be a crime, it requires this specific mental state. As defined by law, animals are deemed incapable of forming it. Mens rea is far more than an animal simply intending to snatch food. In human criminal law, it means culpable intent. This involves the capacity to understand an action is legally and morally prohibited. It requires abstract moral reasoning, which is a uniquely human trait. Consider this: a person plans a complex theft. They are typically aware they are breaking laws. They consciously defy established rules. A magpie taking a shiny object, however, acts on instinct or attraction. It's not deliberately flouting a human legal code it cannot comprehend. This is a key distinction. It explains why the magpie's act isn't a crime. Human laws details a spectrum of mens rea. These include purpose, knowledge, recklessness, and criminal negligence. All are nuanced states tied to human psychology, foresight, and understanding societal duties. Can we truly say a dog who bites was recklessly disregarding a substantial and unjustifiable risk like a human might? The dog acts on fear or instinct. It doesn't perform a human-style risk assessment against legal statutes. This incapacity to form such legally defined mental state is central. It's why animal cannot be held criminally culpable. Another crucial element explains why animal cannot be tried for a crime: the actus reus, or the guilty act. Animal can certainly act, but actus reus requires more. The act itself must be legally prohibited and is also generally defined in terms of human conduct and capacity. For instance, a beaver fells a tree and it blocks the road. The beaver hasn't committed the actus reus of obstructing a public roadway. That law targets human behavior. It assumes a human agent capable of understanding and complying with such rules. Furthermore, the actus reus for most crime needs to be voluntary, willed action by a human. This is judged by human standards of agency and control. Animal actions driven by different impulses do not meet these standards in a legal sense. Critically, mens rea and actus reus must coincide for a crime to occur. Animals are deemed incapable of forming legal mens rea, so even if their action resembles an actus reus, the two cannot concur as required. The inability of animals to form a legal guilty mind or perform a legal guilty act is the key. These concepts are defined by and for humans. The impossibility of these two coinciding in an animal forms the bedrock of the reason as to why an animal cannot be tried for a crime. The purpose of criminal law itself further clarifies why it applies exclusively to humans. Its goals are deterrence, retribution, and rehabilitation. These are all premised on dealing with human actors. Humans can understand laws, they can reflect on moral blames, they can potentially change their behavior due to legal sanctions. This distinction isn't about diminishing animal intelligence or emotion. Many animals are intelligent and experience emotions. However, their cognitive and emotional lives operate outside our human-constructed legal framework. This framework defines right, responsibility, moral culpability, and what it means to commit a crime.